Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers civil lawsuits, probable cause, and the First Amendment, and is brought to us by Columbus Police Body Cameras channel. Be sure to check out the description below and give them the credit that they deserve. In a video posted on November 5th, 2021, the renter of a home in Columbus, Ohio called 911 to request a police dispatch to her residence due to a dispute with a contractor over a roof repair after a sudden downpour caused damage to the tenant's personal property in the home. An officer from the Columbus Division of Police was dispatched to investigate the situation.
Hi, can I speak to you first?
Yeah, I don't care.
Okay, this is just a disaster.
Okay.
I'll just tell you the story. My roof is supposed to be getting done. You know, it started raining, so my whole house is completely flooded now. These are the people that were supposed to be doing it.
Okay.
And they act like they don't really want to compensate us to fix it or whatever.
That's not.
They're going to put us in a hotel tonight and tomorrow.
Okay.
But it's just crazy.
But that's a civil issue. There's
Okay,
not enough police can do about it.
Oh, okay. Well, I didn't know that.
Nah, you could take a police report,
I was a
write it
contractor.
down.
I was a
A
contractor.
police report for what?
I'm just trying to keep it honest. I'm upset. You know what I'm saying? They
Okay.
supposed to do the roof. They didn't complete it. They got paid.
But again, that's a.
And then leaked through
Okay,
and
we
up
didn't know all
all
that.
our...
Yeah, but I'm just saying that's a civil issue. That's something you'd have to sue them for.
But you didn't take a... Okay.
I
You
don't.
don't got to make a report on it at all?
But it would have to be a police, like, what kind of report would you expect me to take?
I don't know. We don't know the police work. We're not you.
And see, I'm upset.
I didn't come here to give you an attitude.
I didn't give you
And I don't
an attitude.
appreciate it back. 'cause
Before I react, I'm
Okay.
just trying to find out what I should do.
I'm
This
trying
ain't
to
my-
tell you.
this
Okay, shut up. Let me
He's
tell
the
us what you-
contractor.
Right.
You'd have to talk to them, and this
I'm
seems
talking
that-
to him.
Stop hitting me, please.
Stop,
All right.
Caesar.
So again, you would have to talk to them, and it sounds like they're trying to put you up in a hotel.
Right. Until
And then,
A hotel.
until the owner of the home.
Up, I got my wife and my kids in there.
okay.
And they ain't looking happy, man.
Okay.
I'm so sweaty. Look at me, man. I'm
Okay.
upset.
Well, that you'd have to.
Walk in there and see that.
Okay.
I got valuables.
Well, you'd have to.
Well, I gave it a chance.
But you'd have to sue them, and then they should be licensed and insured.
The officer informs the tenants that this is a civil matter and that he does not have the authority to do anything about their situation. In the U.S. justice system, civil cases typically involve private disputes between two people, companies, or legal entities after one party causes harm to another, whereas criminal cases are prosecuted by the government against individuals who engage in conduct that is considered harmful to society in general. Police officers are primarily tasked with handling criminal matters, although sometimes their investigations can overlap with civil issues, such as during the investigation of car crashes. The two most common types of civil cases are contract disputes and legal causes of actions known as torts, where one party sues another for money damages to compensate for an injury, death, or loss to person or property, often caused by the defendant's careless or negligent conduct. In this situation, the tenants could possibly have a civil cause of action against the contractor or their landlord for a breach of contract, or they might be able to pursue a tort action against either party if the damage was caused by the negligence of the contractor or one of his employees. However, a police officer would not make a report on this dispute or arrest anyone unless the situation involved a violation of criminal law. Section 2909.06 of the Ohio Revised Code defines the offense of criminal damaging or endangering and states that, quote, "No person shall cause or create a substantial risk of physical harm to any property of another without the other person's consent, if they act knowingly or even recklessly in some situations." According to section 2901.22, quote, "A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result." And, quote, "A person acts recklessly when with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result." Applying these standards, a court would almost certainly conclude that the damage to the tenant's personal property was a civil matter rather than a criminal one, and the officer is correct in asserting that he has no authority to assist the tenants.
I just wanted to see what I should do.
And the owner of the house is coming in from New York. He's flying me. He contracted me to do the roof. I had someone do the roof.
Okay.
So today, while the guy was on the roof, it started pouring down.
Yeah, it was really bad, yeah.
Before he started pouring down, he tried to cover it with the top. Okay, and only that part of the roof wasn't done yet. So it leaked through. Okay, fine. I came over here, they called me, I said, look, let me put you in a hotel tonight for 2 days, tonight and tomorrow, so we can figure out what's going on, and we'll talk to the owner, and we'll get everything taken care of. Okay?
Yeah. Okay, that's
I said, I
reasonable.
can call my insurance company and put a claim in for you and get all your valuables taken care of.
That sounds reasonable.
But he's out here going off on us.
Yeah.
Okay?
I gotcha.
And I have to go to the hotel. I told him I was on my way to the hotel on South High Street to pay for the room because it's in my credit card. They want to see me personally. I can't do it over the phone.
Yeah, I gotcha.
And he's trying to keep me from leaving. So I said, I'll wait for the police to come and explain it to him.
All right.
Okay?
You'll see why.
Sir, I have no doubt that you were upset. I would be upset.
Man.
Huh?
I'm just trying to do it the right way.
I know, and I'm. But after talking to him, he said he's already.
Talking to him, man. Look at
Can I talk to you about it?
Man, you ain't talking right, man. Listen to
How
what
am I
I'm
not
trying
talking to her? I'm trying to explain to you what he just told me.
What'd he tell you?
So he said he's already
He
contacted.
ain't leaving. He is not leaving.
Yes,
He
he
got
is.
a gun in that truck under the seat. And
Okay.
it's not registered.
How do you know it's not registered?
Because I know it for a fact. I told him I wasn't going to tell the details.
All right, Bob. Look.
The tenant tells the responding officer that the contractor has an unregistered firearm in his vehicle, but does not provide any additional information or explain how he knows it is unregistered. Under the automobile exception to the Fourth Amendment's requirement that officers obtain search warrants, which was first established by the Supreme Court in the 1925 case of Carroll versus United States, police officers are authorized to search a vehicle if they have probable cause to believe that it contains contraband. As the Supreme Court explained in the 1983 case of Illinois versus Gates, quote, probable cause is a fluid concept, turning on the assessment of probabilities in particular factual contexts, not readily or even usefully reduced to a neat set of legal rules. And although in some situations an accusation alone can serve as sufficient probable cause to search a vehicle, now quoting again, informants' tips doubtless come in many shapes and sizes from many different types of persons. An informant's veracity, reliability, and basis of knowledge are all highly relevant in determining the value of his report. And as the Supreme Court held in the 1972 case of Adams versus Williams, quote, informants' tips, like all other clues and evidence coming to a policeman on the scene, may vary greatly in their value and reliability. One simple rule will not cover every situation. Some tips, completely lacking in indicia of reliability, would either warrant no police response or require further investigation before a forcible stop of a suspect would be authorized. Given the fact that the tenant made an unsubstantiated accusation against an individual with whom he only had a professional relationship and could not provide any additional information, a court would likely conclude that this statement alone did not contain sufficient indicia of reliability to provide the officer with probable cause to search the vehicle for the alleged illegal firearm.
I ain't
So-
never calling the police again, man.
I'm trying to explain to you what
You ain't
happened.
gotta explain. Get the out of here, sucker.
All right, ma'am. So
Out of here, man.
Go.
Get the out my land. Get the out of here. I never call you again. You're
okay.
get off me, baby. I'm sorry. Use man. I
Why?
try to do it the right way, man.
But he's talking to the owner of the house, and
Get off. Get off.
his insurance is going to pay for the damage
Man,
inside.
It was his job.
I know, and he's already talked to the owner of the house.
You
and
talked to him?
no, he said he did.
Nah, you believe everything somebody.
But the owner's the one who contacted him for the
no,
roof.
he the contractor.
But the owner contacted him, right? Did you guys choose him, or did the owner choose him?
Owner.
Exactly. So he's already been in contact with the owner, and he has.
Don't let him pull off. We might not never see them again. We don't know what the deal is.
But your owner is the one who contracted him. So you can even talk to your owner, and your owner should have to cover the damage inside.
Man,
But
that's why
he
I'm
has
calling.
insurance.
I remember I said that. I'm see, man. I ain't got no
Why are
choice.
you acting like this? I didn't. Because this
Do
is
this shit right.
a non-criminal act.
Use it.
Unhappy with the situation, the tenant begins using profanity, verbally insulting the officer and instructing him to leave his property. Generally, the First Amendment prohibits the government from punishing citizens for their speech unless it falls into a specific category of so-called unprotected speech. The Supreme Court held in the 1942 case of Chaplinsky versus New Hampshire that, quote, there are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. These include the lewd and obscene, the profane, the libelous, and the insulting or fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. When it comes to the so-called fighting words exception, which can include verbal insults, courts have typically held that the standard for fighting words against police officers is higher than for an average citizen. For instance, in the 1987 case of City of Houston versus Hill, the Supreme Court explained that, quote, the First Amendment protects a significant amount of verbal criticism and challenge directed directed at police officers. Speech is often provocative and challenging, but it is nevertheless protected against censorship or punishment, unless shown likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest. Still, in Ohio, fighting words can be punished as disorderly conduct under Section 2917.11 of the Ohio Revised Code, which states that, quote, "No person shall recklessly cause inconvenience, annoyance, or alarm by insulting, taunting, or challenging another, under circumstances in which that conduct is likely to provoke a violent response." And courts have held that this law can apply to speech directed at a police officer. For example, in the 2001 case of City of Kent versus Dawson, the 11th District Court of Appeals of Ohio rejected an argument that the language at issue did not rise to the level of fighting words because the offended party was a police officer, finding that, quote, "Where the offended party is a police officer, a distinction lies in whether the language was non-personal and not directed to the particular officer, and language which was intentionally directed to the particular officer. Therefore, it is possible that a court could conclude that the language the tenant directed at the officer constituted fighting words under some circumstances. However, because the Ohio Supreme Court held in the 1974 case of City of Cincinnati versus Carlin that fighting words can only be criminally punished if they're used in a public place, a court would likely determine that the tenant could not be charged with a crime for his speech.
Okay.
That's why we don't call y'all. That's why we don't trust y'all. That's why we don't like y'all. I can get all the way in your face. You hear me? I know these rules now. Y'all over-policed us all this time.
Okay. Well, you
I
have a
called
good day. All right. All right. You have a great day.
After the tenant expressed his disapproval of the officer's refusal to get involved in the matter, the officer left the scene without further incident. There are no additional details available about the names of the parties involved or whether either party took further action following this interaction. Overall, the unnamed tenants get a C- for maintaining a rude and hostile demeanor throughout the interaction, refusing to consider the information being conveyed to them by the officers, and for verbally berating both the officer and the contractor. It is unrealistic to expect every citizen to possess some degree of legal knowledge, and it is difficult to fault the tenants for calling the police, considering that their property was destroyed and they felt as though they were not being properly compensated. The tenants intended to call the police to act as a civil mediator and establish an official record of what had happened to them, and although they failed to understand the distinction between civil and criminal matters, they still managed to achieve what they intended to do when they initially called. Now there exists objective and undisputable body camera footage that clearly documented their claims, which the tenants can submit a public records request to obtain and use to build a case. Whether or not introducing this footage into a case would be helpful is debatable, but it exists nonetheless. All that said, calling an officer to the scene of a civil dispute is probably one of the most ineffective ways of documenting anything, and it goes without saying that it is a waste of time and resources for all parties involved. While I do empathize with the emotional toll that the tenants were processing, I would caution anyone in a similar position to extensively document the scene themselves rather than relying on a member of law enforcement. This interaction highlights the importance of having a basic level understanding of the legal system, even outside the context of a police encounter. The responding officer gets an A+ for actively working to de-escalate the situation, making a legitimate effort to explain the proper course of action to the tenants, and for remaining within the bounds of his authority throughout the interaction. At no point during the encounter did the officer overstep his authority or do anything to further provoke the tenants. In fact, the officer stayed on the scene, despite being well within his authority to leave at any time, likely to ensure that the situation did not evolve into anything criminal. The Columbus officer calmly explained why he couldn't help the tenants, did so in a respectable manner, and left the scene peacefully. Anything beyond that may have been worthy of criticism, but this officer handled this situation as reasonably as could be expected. I commend the Columbus officer for remaining calm and collected and navigating this encounter with courtesy and professionalism. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.